Welcome, everyone. We're going to give everybody a few minutes to get admitted into the webinar. Well, we thank everyone for joining us tonight. We're going to get started because we have a really wonderful presentation tonight. We don't want to miss a minute of the opportunity to have Jane and Jack who are here with us today. If you've come to see is the North Carolina Supreme Court Poised to Undo Leandro, you're in the right place. So welcome. I do want to tell you a few things quickly. We are going to have a presentation, and at the end, we're going to save time for questions and answers. You'll be allowed then to unmute yourself and ask questions yourself, or if you'd like, you'll be able to put questions in the chat. And so we are going to save time at the end. So if you'll kind of collect your thoughts and hold on to them till a little bit later in the program, you'll have a chance to do that. So let's go ahead and introduce to you tonight our guest speakers. First, Jane Wettach, and you know Jane has been with us several times on several other webinars over time. She is recently retired from the Duke Law School. She founded and directed the Children's Law Clinic there. At the clinic, she and her law students presented public school students, and she represented public school students in cases to enforce their special education rights. That's when I first met and heard of Professor Wettach and her work. And she worked very hard to defend and to improve what was going on with school suspensions and expulsions, especially for our special ed students. She also taught education law and developed expertise in a number of school law issues, including vouchers. And she's been on our program several times to talk about vouchers. She and other law professors and education law practitioners recently submitted a friend of the court brief in the Leandro case, arguing on the behalf of students. And that is one of the things that she and Dean Boger will be talking about tonight. I also want to take a moment to introduce Dean Jack Boger. Many people know who this man is, this young man is. He joined the UNC Law faculty in 1990, and he served for 27 years. Until his retirement in 2017 as Wade Edwards Distinguished Professor of Law. From 2001 to 2006, he served under Julius Chambers as the first Deputy Director of the UNC Center for Civil Rights. Boger was Dean of the UNC Law School from 2606 to 2015, and he was the 13th lucky Dean of that wonderful UNC Law School. His teaching and research interests included the constitutional law, education law, and racial discrimination and poverty law. Along with other public interests and private attorneys, including Jane, Boger helped develop North Carolina's Leandro litigation in the early 1990s. He co-authored several Friends of the Court briefs submitted to the trial court, as well as 4 legal briefs submitted to the North Carolina Supreme Court between 97 and early 2024. We have 2 brilliant scholars here with us tonight, very experienced in educational and constitutional law, to help us understand how Leandro got started, what's been going on, and to talk a little bit about why this amicus brief was filed recently. So welcome, and I'm going to turn it over. I guess, Jack, you're going to go get us started.
Indeed, happy to do that. Thank you for that warm introduction. We are going to tell you about this lawsuit, which was filed originally, as you see from the slide, in 1994 and has been active for 30 years since, on and off. It was filed and fought continuously by 4 low-wealth school districts, and really by the parents and children in those districts. I want to take you through part of the history of that, and the first slide will tell you what that long history looks like in terms of years. If we can move to that slide, you'll see a progress from 1994 to 2020 with more to come. And it's not all background, because much of what's happening right now in 2024 relates very firmly to decisions that have already been made and rendered by the court. So we thought it'd be good to tell you about them. The basics of this began in 1992 or 3 as people across the state realized how many school districts lacked important elements of public education. There were roofs leaking into fourth grade classrooms. There was mold on the wall in places. There were textbooks that were 10 or 15 years out of date, et cetera. And the question was whether there was anything that could be done about that. A lot of it bore on the disparities that I want to take just a minute to explain to you. Most of you probably know, but maybe some of you don't know, the way schools are funded in North Carolina and elsewhere. There are really 3 basic sources of funding for public schools. The first and least important in North Carolina is federal money, because the federal money amounts to somewhere between 10 and 12%. The largest chunk of the money comes from the state of North Carolina, and that's delivered relatively equitably to schools all across the state, to the different 115 districts. That's about 62, 63%. But a large chunk of the money, 26 or so percent, comes from local schools or local school districts. And the way that money gets generated, as you may or may not know, is through the imposition of property taxes. Taxes on what's called real property, buildings and factories and commercial entities and land. And the problem that emerges from that method of raising funds depends on the fact that all counties and all school districts are not created equal. If you think about Charlotte, for example, or Raleigh with their high-rise buildings, all of which are taxable, and their glamorous shopping areas, all of which are taxable, and their heavy the sort of multi-level homes. And then you compare that to a rural district that has no factories and no high-rise buildings and really modest homes. You realize that there's far less taxable property in that district, so that it can tax itself as heavily as Charlotte or Raleigh can, and yet achieve nowhere near as much money. So it has much less money to spend on behalf of its students. And in the early 1990s, as people were looking about those disparities in some of the school districts, they said, is there anything that can be done outside of the legislature, which didn't appear to be particularly responsive to these problems, to insist that there needed to be greater fairness in education? And a number of lawyers and educators got together and started to talk about that, and realized that in other states, there had been a number of suits brought under their state constitutions, not the federal constitution. Because it turns out most states have some reference to education in their constitutions. And the question was whether North Carolina might have that kind of constitution, and whether there could be some movement that would go forward on it. And it turns out North Carolina did and does. North Carolina has a provision, let me read it to you, Article 1, Section 15. And here's what it says. The people have a right to the privilege of education, and it's the duty of the state to guard and maintain that right. And then even more specifically, another article reads, the General Assembly shall provide, not may provide, shall provide, by taxation and otherwise, for a general and uniform system of free public schools, wherein equal opportunities shall be provided to all students. So the lawyers asked themselves, could those provisions be turned into judicially recognizable and enforceable rights for the children and duties that the state of North Carolina must honor? So in 1994, a public-spirited private law firm set out to represent 10 parents and children in 5 low-wealth counties, Polk and Halifax and Robinson and Cumberland and Vance. And indeed, the school districts said, we'd like to be plaintiffs too, because we can't deliver for your children what they need. So they filed a lawsuit in state court arguing 2 things under the state constitution. First, that the North Carolina Constitution required an equal education for students in every district. And that barring that, the North Carolina Constitution at least demanded a constitutionally adequate, if not completely equal education in every school district. Now, the defendants that it sued were the state of North Carolina and the State Board of Education. And they came in through their lawyers, the Attorney General, and said, let's dismiss this whole lawsuit. It doesn't need to go to trial. We don't need to hear any evidence, because the North Carolina Constitution doesn't create a right to anything more than the promise that your child will go to some school. It could be in a barn, it could be in a log cabin, it could be in a wonderful modern facility. That's all that's required. There is no substantive criterion that's supposed to be delivered. So that was their initial response. Now, before the case got to the North Carolina Supreme Court, interestingly, 6 of the wealthiest school districts in the state, Wake and Charlotte Mecklenburg and Asheville and some others, Buncombe County, came in and said, wait a minute, although we've got more property tax and more money, our children have needs that are not being met either. We want to be part of this litigation. So the case came to the North Carolina Supreme Court with no evidence on the legal question of whether there was a constitutional right. And what the court did in July of 1997, speaking through the Chief Justice on behalf of all 7 of the justices, was hold several things. First, that the state was wrong in saying that all that was required was a school somewhere for every child. Second, it rejected the idea that the Constitution requires perfectly equal education in every school district. But importantly for us and for all that's come since, in language that's central, it did say that the Constitution provides every child a substantive educational right. And the right it described as a right to what it called a sound basic education. And it gave that some substance. It didn't just talk in generalities. That said, that's enough education so the child can read and write and speak English well, so they can understand mathematics well enough to use mathematics in a complex and changing society, so they know geography and history and civics, so that they can have enough education to do higher education if they're capable, or to compete equally in the job market after they get out of school. So that was the unanimous right that the court agreed upon. Now, of course, there had been no opportunity to determine whether on the facts that right was being delivered or not. So the court said, we've got to send this case back down to a trial court, to a trial judge, to hear the evidence about whether it's being adequately provided. And it said, when you do that, there's several things you can look at. You can look at what the state and the General Assembly have promised as their educational goals. You can look at what they are in fact providing. But very crucially, you can also look at the output. How well are children doing? If we have, as we do now, statewide tests that measure the educational attainment of children every year, their achievement, to look to see where most of the children are meeting the standards that we've set or not. Now, it cautioned the court going back that, of course, the administration of education is principally a matter for the General Assembly and the state executive branch, education board, and the Department of Public Instruction. And you've got to give deference to them. But if you find by clear and convincing evidence that the children are not receiving the education, then it will be our duty as judges, as courts, to enter a judgment granting the relief necessary to correct the wrongs and give the children their rights. So that's the first big grant. I'll stop, Jane, at 97, and you can take up what happened next.
Great. Thank you, Jack. So yeah, what comes next is that the case goes back to the trial court, and Judge Howard Manning was assigned to the case, and he held hearings over many months and took evidence on all of those things that Jack said that the court instructed him to take evidence on. How are the children doing? What were their inputs? What kind of money was coming in? What kind of teachers were there? And what were the outputs? What were the test scores? What were the graduation rates? What were the dropout rates? How did the students do after they graduated when they went to the local industries? So there was evidence on all of those topics, and the plaintiffs put on evidence and the state put on evidence, and Judge Manning then issued a number of rulings. One of the kind of interesting things during that time is that the state was arguing then that it really wasn't the state's responsibility. It was the local responsibility. It was really the Board of Education that wasn't doing well with whatever it was given. It was the parents, it was the students. But Judge Manning rejected all of that. And Judge Manning ultimately concluded that based on the evidence that he had seen, that the children were not, in fact, receiving the opportunity for a sound basic education. So we now have a right, and we know that the right is being violated. So Judge Manning then had to decide, well, what to do now that we know there's a violation. Judge Manning was very reluctant to tell the state how to fix the problem. It was very clear that there was a problem, that there was a constitutional violation, but Judge Manning did not tell the legislature, here's how much money you have to spend. It didn't tell the Department of Public Instruction how it was to be handling the renovation, shall we say, or the refashioning of how education was being delivered. In one respect, Judge Manning made an exception to that, and he did determine that children who were at risk needed to have some kind of state-provided K-12, I'm sorry, preschool. And he ordered the state to create basically a pre-kindergarten program. Otherwise, he essentially said to the state, you need to go self-examine what the state is doing and come up with a plan. So that's what he ordered them to do, was to come up with a plan. Well, instead of coming up with a plan, they appealed again. And in 2004, the case goes back to the North Carolina Supreme Court. And that decision is known sometimes as Leandro 2 and other times as Hoke County versus the state. People use both. We usually call it Leandro 2 because we've got this series of Supreme Court opinions. So Leandro 2 is an opinion that affirms virtually everything that Judge Manning said. It reaffirms the original principle of the 1997 Leandro case, that every child has a right to a sound basic education. And it also gives a little more meat to that and says that means a competent teacher in every classroom, competent principal in every school, and sufficient resources for every school to support an effective instructional program. But it likewise determined that it wasn't the court's responsibility to figure out how to solve the problem. The court sent it back again to the state to say, fix the problem. And it did reverse Judge Manning on the creation of the pre-K program and emphasized that the state had to have the opportunity, the state meaning the legislative and the executive branches, had to have the opportunity to fix the problem on their own terms. And so the case then, it does not end up including the ruling on the, or the command of a pre-K program. It's a little bit interesting, and this will come back up when we talk later, that they did not reject the idea of a pre-K program because it was a statewide program. And that's going to come up later when now, and when we get to the end, you'll see the legislator General Assembly is now arguing that the court shouldn't be ordering any kind of statewide program. But the state did not object on that grounds, but it simply said it wasn't for the court system to figure out what mechanism would be used to serve those at-risk children. So that was left again with no specific remedies developed by the court, but a remand back to allow the state, the Department of Public Instruction, the legislature, the State Department of Education, to figure out how to get the schools into compliance with the standards that it had set out. So back to Professor Boger for continuation of the story.
Thank you, Professor Wettach. You've got to forgive two longtime lawyers and professors for being transfixed by the idea that what we've got in 2024 is first 7 justices in 1997 saying there is a right that the children and their parents have, and then saying 7 justices again in 2004, and that right has been violated and it will need a remedy. Because that's what we're going to talk about happening over the course of the next 10 or 15 years. The case comes back down to Judge Manning. And while Jane Wettach is right that the state has the burden, they have the burden to do that under the eye of the court, because they've now been found to have violated the rights of the children. And the court's saying, we want to hear from you about what your remedy might be. Well, one of the first things that the state had said, because the judges in the Supreme Court in 2004 had said, maybe we need more hearings. Maybe there are other districts that need to be heard from. But the state said right away, we're going to treat every school district the same. We have statewide policies here. And so you don't have to worry that our policy in Hope County would be different than our policy in Vance County, than our policy in Halifax County. And having heard that, these richer districts that I told you that had got in the lawsuit early to be sure that their rights were going to be also considered, said, we're ready to leave the case, because we know now that between Judge Manning's oversight and the state's promise to treat every district the same, that our children's rights are not going to be neglected. So they left the suit, and Manning began to come and call hearings and bring the plaintiff lawyers who were still there, representing the original plaintiff districts, and the state together and say, now what are you doing? How far have you gone? Have you come up with some new idea for the children who are not doing well? And God bless dear Manning, he would look at every year's annual report on the student test performances like a parent. He would look and say, oh my goodness, look what's happening in Cabarrus County. I see all these children who aren't doing this and aren't doing well on reading, etc. And he'd ask the state, what have you got that you're doing to correct that? The state had a few things that it brought forward, but what they were largely were sort of episodic. We're doing this or we're doing that. There was a disadvantaged student supplemental fund that was created for 17 school districts, but not statewide. That was going to look at the prospect that maybe there were some things that could be done to make a difference. The plaintiff's lawyers kept asking Manning, please, Judge, tell the state that they have to come up with a comprehensive statewide plan. And Judge Manning was originally reluctant to do that. He wanted to give them the opportunity, but he would have a hearing and say, this hearing is going to be about the reading problem, because I can see reading as a problem in districts all across the state. Or this hearing is going to be about the high school problem, because I see high school problems all across the state. And they'd come in and the parties would talk about those things. But he never turned to the state and said, I want you by the 1st of December to have a statewide plan. And it got to 2015, and Judge Manning, I think his patience now sort of on a short tether after 10 years of oversight, said, I am going to order the state to come up with a plan. But before he could do that, he had health problems. And Judge Manning had to step down as a judge and retire. And so there was a question about what would happen next. And the Chief Justice at the time, Mark Martin, appointed a recently retired judge from Union County, down where Monroe is, David Lee, who was 66 years old, and said, it's now your case, take it over. And the state, I would have done the same thing if I were the state's lawyer with the new judge, came in and said, you know, Your Honor, this case needs to be dismissed. Let me tell you about all the records, the boxes of files of evidence and testimony and prior studies and briefs. And you don't really need to look at any of that. You can simply declare this case is now over. But to his enormous credit, Judge Lee didn't do that, but instead did look through all of those records. And he came back and said, this case is not over. I've looked at the right. I've looked at the violation. And my distress is that the children appear to be doing worse in 2016 and 17 than they were doing in 2008 and 9. The direction, the trajectory of education is not a good one in North Carolina for lots of these kids. So he said, you're not out of the case, state, you're in the case. And I think we're going to move toward something more statewide and definitive. Well, about that time in 2018, something happens that often happens in major litigation between contesting parties, and that is that the party decides, you know, I'm going to have to settle this case. I'm going to have to come up with some remedy that is sufficient. And so the state attorney general and other parties and the plaintiffs begin to talk about how might we actually get a grip statewide on what needs to be done. And thought turned toward an organization called West Ed, which is an educational consulting firm in California. And an invitation was extended to them to talk about what they might do to look at North Carolina. And they came up with a very comprehensive proposal. They said, we want to come to North Carolina. We want to talk to scores of superintendents and principals, hundreds of teachers. We want to talk with educational experts. We want to talk with people at North Carolina State and other schools of education. We want to look at all the prior research. We want to do some independent investigation ourselves. And we'd like to prepare for you a report on what would need to be done for North Carolina to bring its educational system into compliance with what Leandro has said it must do. And so ultimately, the parties agreed, let's commission that study and let that happen. And it did go forward. And it came back with remedies in 7 or 8 areas. It said we have some proposals on what we would do about the overall funding system, the way in which money is distributed to school districts, and the alignment of that money with the needs in the local districts. Second, we need to look at some ways in which the recruiting of prospective teachers and their training and their support once they get into practice as teachers needs to be changed so that we can have higher quality, well-prepared, diverse teachers all across the state. We need to support, thirdly, our principals and other educational administrators in a better way than we're doing, with more training and more in-service support. We need, as Jane was talking about, high quality early childhood education, particularly for at-risk children who are at risk because of their parents' circumstances of not doing well in school, so that when they get to kindergarten, they are ready to operate. We need to figure out what services we deliver, fifthly, in school to the K-12 students who are not doing well, particularly the educationally disadvantaged students or economically disadvantaged students. Then we need to look at the assessment system we've been used to test students, and the system we've been used to assess the accountability of schools that deliver that education. And then we've got to come up with a robust set of measures at the state level and at the regional level to bring in support teams. If there's a school that's not doing well, we can bring in people and say, let us help you. Let's figure out what's going wrong with your teaching or your educational administration or the particular group of children you're having to work with. And then they suggested there needs to be an ongoing counsel to the court to tell the court about all the things they were finding. Well, that was a series not only of steps, but particular sub-items in each area that I've talked about, and a timetable. We should start this in the first year. We should start this in the second year. We don't want this to interfere with what we're doing in the third year. So it was a comprehensive way to bring over 8 years North Carolina students and schools into Leandro compliance. And Judge Lee looked at it, gave a lot of attention to it, showed it widely to the parties, and it was in the press, and other people knew that the study was out there. And you're going to hear from Jane about what he subsequently does to make it real, or almost real.
Yes, well, as you can imagine, there was great elation among the advocates for the children at the West Ed report, and Judge Lee's welcoming of the West Ed report. And ultimately, the provisions of the West Ed report became what is known as the Comprehensive Remedial Plan, and Judge Lee adopted it and put it in his order and said, this is the plan. This is what the state of North Carolina must do to remedy the constitutional violations. And so Judge Lee then said to the state, all right, go forth, do it, and come back and give me your progress. So in 2021, the progress hearing is scheduled, and the state attorneys, the Attorney General's office, comes in and says, we're sorry, Judge, we were not able to implement year one of the plan because the legislature did not appropriate the dollars that it was going to take to carry out the steps in the plan. So then Judge Lee concluded at that moment, all right, the legislature has been given sufficient time. The legislature has not appropriated the money. Judge Lee was made aware of a very significant budget surplus that was in the state treasury. And Judge Lee took the step of ordering the controller of the state treasurer to transfer the money that it would take. And by now, year one has passed, but for years 2 and 3, transfer, and he calculated the dollars, $1.7 billion, transfer it from the state treasury to the Department of Public Instruction and some smaller amounts to Health and Human Services and to the UNC system. And told them, that's what you got to do. Told them, the controller, this is what you have to do. So let's say that at this moment, the legal picture starts getting very complicated, and we're going to have to sort of smooth over some of the details to try to move along. But the controller files a case saying, I can't do what the judge is telling me to do because it would violate my duty. And then the legislature passed a budget and said, well, we've actually funded some of that stuff that's in that $1.7 billion, so you can't transfer all of it. And then, most importantly, what happens in this time period is the legislature, in the persons of Senator Berger and Representative Moore, decide it's time for them to be parties to the case. And so they, in a legal term, they intervene in the case, and we are now calling them the legislative interveners. So all of a sudden, after all of these decades, the legislature has not been represented in the case through any separately from the executive department, the executive branch. And now the legislative branch is a party to the case, and they asked to become a party, and they were allowed to become parties in the case. And at this point, the case then gets appealed again. And once they're in, they file an appeal, and the case goes back to the North Carolina Supreme Court, now for the third full decision in Leandro. So in November of 22, Justice Robin Hudson now writes for the majority of the court the next big decision. And the issue there really that was the one brought by the legislature, which was, does the court have the power to effect that transfer of funds that Judge Lee had ordered? So the legislative interveners essentially made the argument that no, there is no power in the courts to force money to be spent. The only branch of government that can do that is the legislative branch. And even in the face of a court saying the legislature's lack of appropriation of money has resulted in a constitutional violation of the children's rights in this state, that doesn't matter. Only the legislators, only the legislative branch can appropriate money. And so they were essentially saying, well, the court can find a constitutional violation, but it can't do anything about it. And so that's the argument that went up at the time of the 22 case. Justice Hudson rejected everything that they had to say. The decision is very long, and it completely reaffirms everything that the majority had said in 1997, everything that the majority had said in 2004, and then added on that, yes, in these very rare circumstances where the legislature has been found to have violated the Constitution by failing to adequately support the schools, in these very rare circumstances when the legislature has had decades of time to do it and has been ordered to do it and has continued to fail to do it, in these extraordinary circumstances, the judicial branch has to have the power to enforce the remedy. And so Justice Hudson, it was now not a unanimous decision, it was a 4-3 decision, but Justice Hudson said the money that Judge Lee said had to be appropriate, had to be transferred, that was an appropriate order. Now, what had happened though was, again, there had been yet another budget. And so the case then was sent back down again to the Superior Court to redo the math to figure out what the right number was. So it was sort of agreed that 1.7 billion was not the number because some of it had in fact been appropriated, but the number that the court came up with was $678 million had to be transferred. So the Superior Court does the math, says 678 million instead of 1.7 billion is the correct amount to be transferred. But the court did not actually effectuate the transfer for some other complicated legal technicalities. But in the meantime, what happens is that the majority of the Supreme Court is changed, or the members of the Supreme Court are changed by the election that we had in November of 2022. And the election did change the justices on the court. The legislative interveners, after a bit, concluded that maybe they had a crack at getting the new majority of the court to reconsider what Justice Hudson had said, and they filed a legal proceeding known as a petition for discretionary review because they couldn't appeal the case. The appeal period was gone and a time for a rehearing had passed. And so they basically just went to the court hoping it would take the bait and reopen the case and reconsider the issues. And the Supreme Court agreed to do that. And that has brought us to the case that is the phase of the case that is now pending. Oral arguments on that issue are going to be on February 22nd in the Supreme Court chamber, and we will have a new hearing. And the hearing is going to be on a very narrow issue, although it has the potential to completely open up all of the previous rulings. And I'm going to now turn it back to Jack to tell you a little bit about the arguments that we made in our brief, and the issues that are to be decided by the Supreme Court when they hear the arguments later this month.
Thank you, Jane. Before I mention what we wrote in our brief, one or two additional thoughts. The court has a very strict rule that says if you've lost a decision in the court, if they've ruled against you, you have 30 days to come back in and says, please rehear this matter. And if the 30 days have come and gone, I could cite 24 cases all the way back to the 30s and 40s saying it's over. You can't come back later. Well, the legislative interveners didn't come back and say, please rehear this matter, even though the election that put new justices on the court and changed the political complexion of the court took place within that 30-day period. They really waited until February or March or April after a November decision to come back. And they did so in a slightly odd way of saying, gosh, there are all these issues that have not yet been resolved. But when you look closely at them, and part of what's happening on the appeals that are before the court now are the plaintiffs and others looking at them, they're the very same issues they raised 2 years ago. Indeed, the plaintiffs go to the trouble of saying, look at the language of the brief they filed in 2022. Look at the language of the brief they filed on this point in 2024. They're using the same words, the same sentences. And then you, the court, we will take what the majority, Robin Hudson, wrote, and the dissent, and both of them have addressed it. So the idea that this case has not, these issues have not been heard is strained. But of course, what it is an attempt to say, please ratify the notion that you don't have the power as a court ultimately to tell us what to do with the dollars that belong to us as the custodians of all the resources of the state. And so it goes into what lawyers would call separation of powers issue. What's the power of the court? What's the power of the legislature? What's the power of the executive branch? Well, our brief was really written on behalf of some 21 people, all of whom are law professors who have taught constitutional law or educational law or racial justice law, and a couple of longtime practitioners who've been involved in the Leandro case as sort of lawyers back to the early 1990s. And that group of people from every law school in the state, except for Elon, which for some reason we weren't able to get in touch with, but from Campbell and Duke and North Carolina Central and UNC and Wake Forest, all concur that this is a case, as you've heard, for 30 years that's been about children and children's rights and education and the duty of the state to provide that education and the demonstrated failure of the state to do so, and how we can get some remedy that will ultimately give them what they've long been promised. And our argument is the legislative interveners are attempting to divert the court's attention away from the children, away from what they need and what they have not gotten, by talking about issues of constitutional power, who has the power to act and who doesn't, and claiming this right to unreviewable power. And we, in fact, say in our brief, normally you're right. Normally it is the responsibility and the duty of the state legislature to make those choices. But when you have been found as a legislature to have failed to do, not for a month or a year or even a decade, but over several decades, what you're obliged to do under the Constitution to adequately fund the children, then at long last, as Professor Wettach said, there comes the moment where the court has to stand up and say, you are subject to the law, just like any other entity. Just every person, every entity in the state is under the Constitution. You are too. And if you're not doing what the Constitution requires you to do, we, the court, must, at the end of the day, sort of enforce that right ourselves. And we've done so inobtrusively. We haven't told you, you must spend the money. We've gone straight to the treasurer and say, cut the check and send the check to the educational entity so that matter can be addressed by them with the funds they need. We then make the argument that I've made to you. All your previous issues have been expressly asserted and rejected. So those issues aren't there. And then finally, we sort of say they're trying to tempt you to abandon your judicial role and think about what would happen if you do. Every one of those judges that's previously ruled that there's a right and a violation and a remedy to be given would be told you're wrong. The parents and children who had held out the hope that the constitutional text meant something, as you have been told, would be told those promises are empty promises. And the court would be told itself, we don't have the power to do what needs to be done to protect the rights of your children. And we said, we hope you're not going to take that step. But if you do, you ought to be honest about it and just say, there's no more constitutional right for these children. So we've left them in that posture trying to say, please do the right thing in this moment as judges for these children. And we should stop and see if there are questions about where things stand.
If you'd like to ask a question, please feel free to unmute yourself, raise your hand, or just speak up. Does the delay get factored in? Someone puts in chat. And
I'm
the
not sure
settlement.
exactly what that means. Yes, I think at least the argument that's made is that the delay in the enforcement of the right shows that the courts have been acting with great restraint, that they're not acting impetuously, that they're not trying to sort of be the most sort of dominant force. They've said, we have waited long and patiently for you, the legislature, to act, and your failure to have done so on full notice of what was going on is a factor that justifies our ability to step forward now. Wouldn't you agree, Jane?
Yes, I would. And I also wonder if the questioner is thinking about, well, what about all those children whose educational lives have come and gone during this time? Is there any remedy for them? And I would say, as a sad matter, probably not. We have the ability to try to go forward and improve our schools for the students who are there now, but the students whose educations were at risk in '94 when they brought the lawsuit, and they've all sort of, they've certainly all come and gone. Rob Leandro, who was for whom the case is named, is now a lawyer practicing law. And but there's not going to be an opportunity to go back, at least not back further than the comprehensive plan. That would be my assessment.
I think
go ahead, Jack.
There's some wonderful questions in the chat already.
Right.
And some of them are asking about, where we are in the process, because we're now 2 or 3 years in. I think what would happen if the court were to reaffirm what was done in 2022 is they would once again send it back down and say, where are we, state? How much money needs to be dispersed? What needs to be done in years 3 and 4? And in good faith would try to work that with the legislature to make that happen, unless the legislature stayed in defiance. Someone asked whether the legislature was in contempt of the court. Not quite, because they came to the court to say, we don't think you have the power to do what you've done. And the court has now said, we do have that power. We're going to do it. The contempt might arise if the legislature continued to defy. And yet the genius of Judge Lee's version of this is worried about the prospect that the legislature might be reticent to do what it was supposed to. Instead of saying, you must do it, and they say, no, we're not going to, they said to the treasurer, who's just an administrative official, write the check, send the money to the State Department of Public Instruction. It's harder for them to defy that, except by coming into court and saying, no, please don't do that.
Chris, go ahead and unmute.
Thanks. Great presentation. Good to see you both. One question I had that I haven't heard come up in any of the stuff I've read is, there are several pieces of the Leandro plan that don't have to do with money. So several policies that could be implemented, and those seem to have been left by the wayside. Either, the legislature isn't even bothering to argue against why they shouldn't have to do those things. And on the other hand, the good guys aren't really using that lack of compliance as evidence of sort of willful negligence on the part of the General Assembly. I'm just wondering what you thought about that. Thanks.
Go ahead, Jack.
I don't know the details of that well enough to be sufficiently sort of useful to you. If there are matters that don't require additional funding, but just require, say, the State Department of Public Instruction or the Board of Education to do something differently, then I suppose the plaintiffs could come in, and probably should come in, and say, we want you to enter an order to them to say, please enforce those elements. I suspect that their attention right now has been focused on this big question of whether the money will flow. And it's hard to predict when and where they would come and do what you've described. But they might try to do that even if they lost in the Supreme Court. If the Supreme Court said you can't spend the money, that only the legislature can spend the money, they might say, well, let's look at the financial aspects of this and start to require those as well.
Jen?
Hi, thank you for a wonderful presentation. I'm here in Union County, so it was interesting to hear that David Lee is from Union County. I apologize, sorry. My question is, how do you think that the legislators are trying to really force the voucher program, and how that is defunding public education to take away from the money that's already in the school system? And what will that do if they push the Leandro and we actually win and they actually have to fund it? I hope that makes sense.
Yeah.
Right. Yeah. Well, right now, North Carolina can do both if it wants to. North Carolina has the capacity to fund our public schools. And if the people through their legislators want more support of private education through the voucher program, it could afford to do that too. Right now, the legislature is in my view, preferencing the voucher program over the full funding of the public schools, but it certainly could make other choices, and it could fund both if it chose to. And if, one of the things I just wanted to be sure to say is we have an election coming up, and we have legislators who either support public education and are going to push to fund it more fully, or they don't care. And the majority right now has shown, at least in my view, that it really doesn't care about fully funding. In fact, is rather aggressively opposed to fully funding the schools. And we need new legislators who are going to change that tune. So tell your friends to get out and vote.
So I'm going to go through the chat really quickly just to see if someone says, have the interveners acted in contempt of court?
And my answer to that was not quite yet,
Okay.
because they've come back to the court to say, we don't think we should have to do this. If the court tells them again, no, you do have to do it, and they refuse, then they would potentially be in contempt.
And so some people want to know if the courts on the 22nd of February or whenever they make their ruling overturn Leandro, will there be any opportunity for appeal, or does this mean that it would have to go to the Supreme Court?
It's a state constitutional provision. The federal Supreme Court has no jurisdiction over it at all. This would be the final word. Of course, if they were to do something that precipitous, and one of the arguments that's being made by a lot of the parties is that courts are unlike legislatures in that they're supposed to follow the precedents that previously have been announced. Legislature can come in and say, we don't like what the last legislature did, we'll just change it. But a court's supposed to say, gosh, I wouldn't have voted that way if I were on the court at that time, but we did vote that way, and this is judicial law, I will follow it anyway. If they flip on what's, 25 years of constitutional law and say, oh, that was always wrong, there never was a right, or if there's a right, there was never a violation. If there was a violation, we can't enforce a remedy. Then they really invite a subsequent court to come in and say they were wrong. And then you don't really have what lawyers and citizens think of as courts anymore. You just have another kind of legislative branch. So there's an argument to be made to them. The integrity of your own judicial special nature is at risk here if you defy what has previously been done. But they might do that. We'll see. Hope not.
Right. So another, several folks are saying you have any notion about what they might do, any predictions, or what are some likely outcomes? I don't know if you want to even go out on that limb, Jack or Jane.
There are two things I just want to bring up. And before I address that, you've got some wonderful slides you ought to show at least one of, showing what the real world impact of Leandro would be in every school district. And I would urge you, even before we get to that question that you raised, to show at least one of those. Not the roster of things that it addresses, but what it means in terms of the budgets of those states, of those school districts, because you've got 3 or 4 that are highly dramatic.
Okay, let's jump ahead
Yeah.
there, and Heather, maybe run through a few of these that we wanted to
I can
share.
go through these really, really very quickly because Professor Boger and Wettach talked about the specifics, like these 7 categories. And every child NC and Chris Nordstrom, who's on the call, did this fabulous work putting together a data tool. And we have the link over here. So when you get these slides, you'll get this link. I encourage you just to go to Every Child NC and poke around and find this tool. You can go in and pull up a district. They have it for statewide, but you can pull up a specific district and see exactly how many dollars in what category is owed, basically, to the districts through Leandro. Now, this was last updated in April of 2022, so the specifics probably are way higher now, but percentages are probably pretty similar. So here's Charlotte Meck. You can see with the current state funding, well, under Leandro, they are owed. This is 2 years ago, they were owed $278 million. And that would increase their operating, the money they get from the state by 30%. And over here on the right-hand side, you see the teachers, how many teachers, teacher assistants, psychologists, and all of these specifics. So they have a number, every district. So you can go in there in your district and see the huge dollar amounts that are being held back from districts for years now because of this legislation. So here's Cumberland County, one of the original Leandro districts. So they would be getting more than $131 million, an increase of almost 40% of the money they get from the state. And over here, 520 teachers, et cetera.
And all of that is at risk on the 22nd of February. That either comes or doesn't come, depending on what the court does.
Yeah, it's huge amounts that will have a huge impact on the lives of public school students and all of the staff. It's just very large amounts.
And let's show a couple more rural counties real fast, and then we'll get on this.
Yeah, let me just show down here. We also have the Office of State Budget Management did a projection of, now that we have these voucher expansions, what the districts are going to lose likely. So if half of the students come from public schools. So this is 17 million that they're going to lose because of this voucher expansion. And at the same time, the legislature is holding back this Leandro funding. So we've got holding back funds and then this loss. And here's Halifax. We've got a 41% increase, $7.7 million that they haven't received that they should have already received. And they're projected to lose $830,000 just because of voucher expansion. And here's Northampton at $4.6 million that they should already have using. They should be able to use this already, and all these teachers and staff, 33% increase in what they're should be operating with right now. It's just huge numbers. So go to the Every Child NC website, look at the data tool, and share the information with every person who votes. They're large numbers.
Okay, so let's go back one ahead. Let's don't do this one quite yet, Heather. I just want to make sure before I want to go back really fast because I know we've said 7 to 8 and we're there. But I wanted to go back really quickly in the chat and really just ask our guests who've been so patient to be with us. Is there any question that we didn't get asked, or there's something that's burning you think's important? We have talked about, will it be the live streamed on the 22nd? They did that in the past. We are anticipating it will be done then. Are there any other quick questions or comments? You can feel free to unmute yourself or ask a question. I don't want you to go away thinking we ignored your comment in chat. There have been some wonderful questions here. Anyone before we move forward? So,
Hello, sorry, it's Jen again. I'm sorry.
oh,
I wanted to ask real quick, what can local school board members do? Like, I go up every month and I tell them about the vouchers defunding, and Leandro money could help in our budget, and we're going by the skin of our teeth in our county. And I constantly tell them to reach out to legislatures and fight for our district. How can we encourage our elected Board of Ed members to do their part to tell legislators we want the money back in our school districts?
well, Jen, that's what we do. Public schools first that's what we do every day. What we believe very strongly is that we have to continue to communicate to the public. We've got to show everyone what's happening in the General Assembly, what's at stake, what they're losing, and so forth. We also believe that the grassroots approach is very effective. You know, I think that school board members, commissioners, city council members, they should be talking to their legislators, especially in some of these small rural counties where these are the places where the chairs of the appropriation committee live and the chair of the education committees live. We've talked to them a lot. They're not listening to us. I do think they will listen to their voters, their folks in their community. So I think don't give up on that, right? Because when school board members say you're hurting our economy if you close down our schools, and the double whammy that Heather showed you there between here's what you're not getting, we're not funding you, we're not even adequately funding you, to get the word fully. And then we're also going to continue to create a situation where dollars that have never been in the line budget before, kids who are sitting in private schools right now, their families are applying by the thousands to get their coupon, their voucher. And what that does is erode the education budget. And I think Jane did a great job of saying, you know, this doesn't have to be an either or. We could argue philosophically about whether you should have vouchers or not, but the budget coffers are full. And if we were funding Leandro, we could still have other programs in the state. It's not one or the other. So Jen, keep it up. We believe in educating people to be an educated public education voter. And it starts with everybody in your own community. I believe that very strongly.
Well, this is Eva Clayton. Can you hear me?
Yes. Hey,
Oh,
hello.
yeah.
What an honor to have Eva Clayton with us. Welcome.
Thank you. I want to thank you for a wonderful discussion. I've heard of your presenters before, but I want to say that we want to put public education on the ballot this time. And the only way you can do it, if this doesn't stimulate you to get out there and make sure that your elected officials know that you support this is our opportunity. I think we have the best opportunity to raise those issues with your Board of Education, that they will raise it with their elected officials. So hopefully everybody on the line will make sure they try to do their best and putting public school support on the ballot.
Thank you so much, Representative. You know, if you don't know Eva Clayton, she served this state well in many, many capacities, including in Congress. And we're honored to have her join us. And I'm honored to hear that she's in the fight this year to make sure public education gets its just desserts. Rebecca, I see you have your hand raised. I know some of you may have to drop off, and if you do, I understand. But I want to give a few more questions. Rebecca?
Thank you so much, and thank you for taking my question. This has been fabulous. I was just wondering, how do we hold judges accountable other than letting them know that we're watching? I mean, there has to be, I don't know hardly anything about the law, but what I do know is a little bit from civics class. Number one, there's this thing called 3 branches of government, which means 2 of these branches should be talking about this right now. The other thing that I'm kind of wondering about is, if you're not supposed to try something that has already been tried, the gavel has slammed and no new evidence is appearing, then isn't a rather unprincipled decision to rehear this court case at all? And aren't there ethics? Aren't there repercussions for acting in an unprincipled manner according to your profession when you sit on a bench?
I don't think you see them brought before any, kind of judicial ethics committee for doing it. It really would violate longstanding notions of how courts are supposed to operate, and yet we've seen that in other courts with other justices doing things that are quite surprising.
All of our judges are elected. That's all, I can say, that's the only way that any citizen can hold any elected folks accountable is to show up and vote with knowledge. I want to just, is there any, while I'm waiting to see if anybody, Francis, I see your hand up.
Yes, my name is Francis Coster. I'm a retired pediatric healthcare administrator that runs a 501c3 that inspects schools for pollution. According to EPA, 50% of all the schools in America have pollution in it that is harmful to the children. There's a large amount of scientific evidence that indicates that some kinds of this unhealthy environment lowers learning. We've been surveying schools since 2017 here in North Carolina. And 40% of the schools that we have surveyed will lower learning 1 letter grade every year cumulatively. And 10% will lower learning 2 letter grades every year. And when I looked at the spreadsheet, the slide that talked about the allocation of where the state money would go, I didn't see anything about improving the buildings or the indoor conditions, which have as much a detrimental impact as other socioeconomic status indicator.
Okay, so Francis, let me speak to that really quickly. There are many efforts been made to bring more capital dollars to rural and smaller counties. And these have been blocked. We have been begging for over a decade for a statewide capital bond to help rural small communities be able to fix and repair and maintain their buildings. And it has not passed out of the Senate or the House, one or the other, for almost 13 years now. So that is a real problem. But the way our funding is set up in North Carolina is that local school boards and county commissioners are responsible for the capital improvements on buildings. And so that's a separate kind of issue. And that's why that is not a part of what we need to do to make sure that kids, when they show up and sit in a seat, that they have the instructional education and support system they need. I think you're absolutely right. I'm appalled. I know that Wake County has a rich tax base, and it's able to do a lot of these things. Halifax County does not. Robeson County and Sampson County do not. So I think it's an ethical and a moral imperative that we care more about how we treat every child in every zip code in every county. And you're just bringing out another example of how we have failed our children. So thank you for doing that. But I am going to let everybody go now. But I wanted to say two things. Heather, if you would show that day of action, Jen, Rebecca, Francis, all of you have kind of said, what can we do? And what I'd like for you to do is to show up for the day of action. Now, you may not be able to actually come to Raleigh that day, but we're going to gather outside the courtroom, across the street from the North Carolina Supreme Court. We are going to be there to talk to the press. We're going to be there to share our views on how Leandro should be upheld and it should be funded. And we're inviting you to come. If you can't come for the whole time, come from 10 to 12. That's the most important time where we're going to be marching to the General Assembly. We're going to be having a press conference. And then there'll be other opportunities. If you can, stay for lunch, stay for a teach-in. But if not, if you cannot come at all, please do me this one favor. Please write your legislators and let them know how you feel. Write every single one of your local legislators and go to your school boards and your county commissioners and ask them to pass resolutions supporting Leandro and putting a moratorium on vouchers. So again, I think if you can get involved at the local level, do it. And Jen, when you and Rebecca were talking, I thought you should write a letter to the editor. Your comments were wonderful and made such brilliant points. So write letters to the editor, write and share your views. Okay. So the last thing I'll say is we are working really hard. We're a very small group of nonprofits, a very small group of part-time folks who really, really need your help. So, and the biggest thing we need is your voice. We need you to follow us, to come get on social media with us. We're going to be presenting those slides that you like, Jack, of those counties that shows what they have at stake. We're going to be publishing those 2 or 3 every day for the next month. And we want you to see those. We want you to share those. We want you to send them to your parents, to your church members, to your synagogue. We want you to help us get the word out. We are failing our children. This is to me, it should be illegal to do it, but, and we can't hold people accountable the way we want, but we know it's unethical. And I am going to close there, but Jack or Jane, do you have any final comments you want to make? And thank you so much for coming. You both have retired. Instead of spending time doing things that you would like to be doing, you're spending it with us. And so we're so grateful, but I want to give you a chance to have the last word.
Jane?
Just thanks so much for doing this program and all that you do. The lawyers can only do a little bit. And as you said, it's the people who are out there trying to influence their legislators and the governor and everybody who's in power to start doing the right thing. And so your leadership in this area is really greatly valued. Thanks.
I agree. I think it's really important for the lawyers to do what they can, but then for citizens to speak up and talk about these matters, including the capital expenditure problem that's not even being addressed by the way our system is set up. One final thought as I was listening to people talk about the data. Imagine your own household budget. If somebody said, we've got 39% more than you have in your budget for your home, would that be something valuable to you and your household? And that money, as Jane said, is available. That's not money we wish we had. That's money we do have that's not being allocated, even when they're told you're obliged to allocate it. So it's a powerful message to take to local school boards and parents. Thank you for this.
This recording is going to be sent to everybody. A link to it's going to be on YouTube. So share it with your friends. Let other people hear how this presentation by Jack and Jane, because they took a very, very complicated process, 30 years in the making, and made it much more understandable. And hopefully it will give you the ammunition you need to talk to your neighbors, your friends, your elected officials in your local communities, and to speak up in Raleigh on the 22nd. So thank you all. Again, thanks for all our attendees, and thank you for our presenters. And I'm sure we're going to, maybe we can talk you into coming back later, when we see what happens on after the February 22nd, maybe we can get you to come back and help us distill where we end up.
We dodged your question of what we thought might happen. We left that alone. We can come back after the 22nd and tell you what did happen.
Okay. All right. Good night, and thank everyone for joining us.
Thank you.
Bye-bye.